Kogod versus Cioffi-Kogod, 135 Nevada Advanced Opinion Number 9, decided April 25th, 2019, was perhaps the most important family law case decided by the Nevada Supreme Court in the past several years. There were three primary pieces to the opinion, addressing the questions of alimony, marital waste, and the length of the community. By way of background, the case was something of an outlier with highly unusual facts. The Kogod divorce divided an estate valued at some $47 million. Most of the opinion dealt with the degree and rationale for how or why that estate might be unequally divided between the parties. The opinion expounded on alimony at some length, ultimately deciding that even though alimony might be awarded on some basis other than need, no alimony was warranted here, where income-producing assets awarded to the wife would produce passive income sufficient to maintain her marital standard of living. The court listed a couple of guidelines for future alimony cases, saying that alimony could and should be awarded when necessary to support the economic needs of a spouse or to compensate for a spouse's economic losses from the marriage and divorce, including to equalize post-divorce earnings or help maintain the marital standard of living. There was a lot of detail, as explained in the article referenced at the end of this video. Unfortunately, as explained in that article, while the decision went some distance to advancing alimony theory in Nevada, the court's discussion also added a bit of uncertainty and contradiction to every alimony analysis by simultaneously trying to address the concepts of need and loss, which are actually alternative ways of addressing the subject. As explained in my article, A Uniform Approach to Alimony, How Alimony Should Be Calculated and Why, there are not really two analyses set out by the Nevada statutes, but 7, all of which should be examined in any alimony case. During its discussion, however, the court did adopt, without using the name, which I've labeled the alimony bell curve, essentially setting out that there are two groups for which alimony is not really a relevant idea. First, one edge of the curve where everyone is so poor that there's plenty of need, but no real ability to pay once self-support for both parties is considered. Second, and this is where the Kogods were, where there is so much property being divided that there's plenty of ability to pay, but no real need, in that any alimony award would not have any significant effect on the lifestyle of either party. In that kind of case, any alimony award is essentially just a gratuitous transfer of more money, as explained in my article. Those making or defending against an alimony claim might benefit by stepping through the full analysis set out in the article. The second major holding in Kogod had to do with when the community ends. Even a lot of lawyers don't really understand it, but the states vary about when the community ends. Take California, Nevada, and Arizona, 3 community property states side by side by side. In California, the community terminates on the date of final separation. In Arizona, the community terminates on the date of filing and service of a complaint for divorce. And in Nevada, the community terminates on the date of divorce. In Kogod, the wife cross-appealed on the question of whether she should get a portion of the money earned by her husband between the date of the divorce trial and the formal date of the entry of the decree. The Kogod court agreed with her, holding that the date of divorce meant entry of the decree, which gave the wife half of all the salary the husband earned between the date the parties were declared divorced and the date the decree was actually filed. This was probably a bad idea for several reasons. First, It runs directly contrary to what the court has done in similar cases for decades, and even contradicts the court's own partition cases. Second, the decision was contrary to the decisions of other courts around the country that have examined the policy ramifications a bit more closely. Third, it encourages one party to delay entry of the decree to try to make a buck, instead of encouraging everyone to try to get the paperwork done and filed as soon as possible. It would have been a far better policy choice to define the time of divorce as the close of the divorce trial. But if the court won't change its mind on this point in future cases, it will be necessary for the Nevada legislature to do so. And it might be a good idea to redefine the community as ending on the date of filing and service of a divorce complaint, like Arizona does, which appears to solve most of the problems that appeared in Kogod. The third major holding in Kogod had to do with waste claims, but unfortunately, the court somewhat muddled the issue. Waste, also called dissipation, is the expenditure of community funds for non-community purposes. In two earlier cases, Lofgren and Putterman, the facts were a bit simpler. In Lofgren, the husband basically went to his dad before the divorce and said, "Dad, here's a big bag of cash, hide it, and I'll be back for it after the divorce." The divorce judge said, after he figured it out, that that was a bad thing to do and awarded the wife more money. Most people can understand the simple logic of the case. Putterman was a little bit more complicated. The judge was less specific as to exactly what the husband had been doing wrong, but whether it was padding his expenses, underreporting his income, or other economic bad acts, the district court's judgment giving additional property to the wife was affirmed on appeal. But in Kogod, the Supreme Court first declared that waste could only exist during the marital breakdown, and then it violated the standard it had just set out, making the whole subject more confusing. Specifically, the court found that the waste claims were restricted to the time of the marital breakdown when dealing with miscellaneous expenses. But it found that gifts to family were only potential waste if they were unprecedented during the marital breakdown. And it also found that all of the husband's expenses on his second family in another state, going back a decade, constituted waste. The problem is that the court's holdings are analytically incompatible. Timing either is or isn't a critical element for making a waste claim. But the decision went both ways, and therefore made the law a more muddled mess. Under Kogod, it seems inescapable that fault has worked its way back into the property analysis in Nevada, at least in consideration of waste claims. Combining the sections of the court's property and waste analysis, they appear to stand for the proposition that fault is irrelevant in Nevada property division, and expenditures may only be considered waste if they are made after the marital breakdown, when divorce is imminent, unless the husband had an affair, however far back that might have been. That doesn't appear to be analytically sound, and it doesn't provide any adequate guidance in an age when the definition of marriage has changed considerably, in which plural marriage is openly examined in popular culture and discussed as a potential legal challenge to existing forms, and where Monday morning quarterbacks might have very different views of the morality and acceptability of the personal lives of others. It is unclear whether the test for waste should be objective, subjective, or mixed. Whatever the answer, clarification in a further case seems necessary. Courts can only be expected to issue orders and opinions consistent with community property and alimony theory if the appropriate legal theories are cogently presented by counsel in their filings and argument. Kogod was an outlier of a case on its facts, and while it is a useful advance in expanding the published Nevada authority on family law issues, and it may well have reached proper conclusions on the facts of the case at hand, it fell short in several areas of logic, theory, and public policy that are going to require either further cases or legislation to make right. For a more detailed analysis of these issues, see the two-part article titled Kogod Contradictions, Practical Problems, and Required Statutory Fixes, posted on the Published Works page of the Willick Law Group website. Thank you.